Moving on to our first session of the day, I invite Mr. Ratan K. Singh, who is the moderator for the panel. I welcome Ms. Rena Scott, partner and head construction advisory and disputes at Pinsent Mason, Saudi Arabia. Mr. Hamish Lal, founder Hamish Lal Partners and former chair SCL UK. Dr. Professor Sundra Raju, international arbitrator and former director AIAC. And Mr. Ajit Mishra, executive director DFCCIL. I would now request Mr. Singh to commence the panel.
If you will have too much of tea, you will miss the lunch. I don't think that is an appropriate way to go about it. Ladies and gentlemen, may I request all of you to come inside and give a big clap to all my panelists. I'm privileged to have very stellar panel of eminent construction arbitration and construction law professionals from diverse jurisdictions. On my right is Rena Scott, who has studied law in USA. And Rena, you have practiced all across the jurisdictions. Hope I am right. I am. Rena will be talking about, because of her exposure to all the jurisdictions, common law jurisdictions, civil law jurisdictions, Sharia law jurisdictions, she will be the right person to give us perspective about the SCL protocol of industry, how industry looks at this SCL delay and disruption protocol, what industry thinks about SCL delay and disruption protocol. On my left, Mr. Hamish Lal, old friend, and Hamish was chair of SCL UK, so he has worked with SCL UK very closely. And once Hamish told me that we are working on improvement of SCL delay disruption protocol. So why can't you also contribute towards this? Hamish was heading the construction practice in Gump, and now he runs his own chamber. Hamish is a well-known name in construction, arbitration, and dispute world. And on the left of Hamish, my old friend Sundra Raju, one thing common amongst two of us would be that Sundra was the founder chairman of SCL Malaysia. Sundra was director of KLRCA, which is now termed as AIAC, the most prestigious arbitration institution in Malaysia. Sundra is a qualified architect, qualified lawyer, and experienced arbitrator. He regularly sits as arbitrator for high-stake construction disputes in all capacities as chair, party nominee arbitrator. So he again has got very wide experience of the industry. And on the extreme left, my vice chair of SCL India, my dear friend Ajit. Ajit Mishra has been heading Dedicated Freight Corridor Corporation Limited. DFCC has done the work for dedicated freight corridor, and which was, I would say, in the recent past, in recent history, I would say, was the biggest investment by government of India for having dedicated freight corridor all across the country. Distinction of Ajit is that he's not only an engineer from one of the IITs, but he is a qualified trainer for PD forms of contract. Ajit has spearheaded dozens of international construction arbitrations seated in London and Singapore. He has been involved in hundreds of arbitrations. So again, he will give us the employer's perspective, how employers look at SCL delay and disruption protocol. Few words about SCL delay and disruption protocol. We heard from our eminent speakers, dignitaries in the inaugural session. My Lord Justice Bindal talked about delays and consequences of delays. Her Ladyship Justice Malhotra talked about consistency in the arbitral awards. I'll give you two statistics. One's Chartered Institute of Arbitrators UK branch. In fact, I am associated with CIRB India branch for last 13 years as director. My co-director, where is he? He has disappeared. So, one CIRB UK branch formulated a construction dispute proposition on delay and delay claims and gave the same proposition to 5 eminent construction arbitrators. Ladies and gentlemen, all the 5 arbitrators came out with different findings on liability side as well as on the quantum side. Another example, in USA, and you would know that in USA you have construction legislations like UK has Housing Grants Act, and now you have security of payment legislation. Justice Bindal also talked about this. In many parts of the world, in fact, my friend Sundara was the instrumental in bringing SIPA in Malaysia when he was heading KLRCA, and I know, and I remember having been to KLRCA building, old building, not the new one, and there I could hear Sundaraj struggle to convince the government departments to bring on board to have legislation on construction law. Going back to what I was talking about, the example, in USA you have, if a contractor has got any construction claim against any governmental and public authority, you have got a special courts, federal claim courts, and the judges manning them, presiding them, are experienced construction decision makers, I would say. They have got very, very developed jurisprudence on construction law. Mark is sitting from my chamber, Keating Chambers, London. Head of my chamber now, Alexander Nishan, King's Counsel, is also ad hoc judge of Technology and Construction Court in London. So in those jurisdictions, You have construction legislations, you have construction courts, and certified and accredited construction professionals. In fact, I remember 2016, I was speaking in a conference in Singapore, and I was asked 3 questions. Do you have construction courts in India? Do you have construction legislations in India? And do you teach construction law in India? And ladies and gentlemen, answer to all the 3 was in negative. This is the inspiration for having SCL and starting the whole process here. Going back to what US example is all about. In US, same proposition on delay and the quantum of the delay claim was given to 15 arbitrators. And again, they came out with different conclusions and findings. I understand. In any decision making, whether it is construction arbitration, about construction arbitration, or about any other branch of law, there is some element of subjectivity, we all understand that. But, and this big but is the thing, how do we have consistency which will give rise to a legitimate expectation to the parties to the dispute, how to go about it. And this is where protocol like SCL delay and disruption protocol comes in. It basically sets a standard. What it does is, it tells you, and SCL delay and disruption protocol, I would say everybody sitting in the hall who did not have occasion to read this document must read this document once if you have got anything to do with this construction industry. It tells you and it gives you the theory of various fundamental and first principles of construction, about construction industry. My Lord Justice Bindal was talking about delay. What is delay? Generally, in construction law, every delay is not delay. Only those delays which impacts the activity on the critical path and ultimately extends the completion date is delay. Otherwise, it is not delay. It may be disruption. Now, therefore, SCL delay and disruption protocol tells you what is delay, what is extension of time, how to ask for extension of time, what is acceleration, how to determine delay and how to do the delay analysis. 6 methods of delay analysis. As I said in the inaugural, every delay expert refers to SCL delay and disruption protocol. It is amazing document. Yes, for different stakeholders, it may have different meaning. And this is, ladies and gentlemen, we are going to talk about and hear from very experienced panelists. And for that, I would request Reena, lady first, Reena.
Good morning, or good afternoon now. Thank you to the conference organizers for the kind invitation to speak today. And thank you to my co-panelists. I only have 10 minutes, so I'll jump right in. I'm going to keep to my 10 minutes because I stand between you and a long day. So I will focus my comments today on the SCL protocol in practice. One second. There we go. And specifically, how the protocol can impact construction advisory and disputes practices in a positive way. As many of you are aware, as legal practitioners and participants in the construction industry, the standard form contracts, and oftentimes the bespoke ones as well, don't provide much by way of guidance in terms of how contractors should go about the process of preparing claims. Nor do they guide employers and their representatives on how to make fair assessments of contractor claims. Instead, the instruction is often to simply submit a fully detailed claim. You see this in the FIDIC form. This, of course, leads to inevitable complaints about engaging with contractors and their claim submissions. The most prominent complaints fall into the categories I've listed here. Project records insufficient to factually assess contractor entitlement, responses to contractor notices lacking reference to factual context, delay analyses not assessing the location of the project critical path, no real analysis of project records to anticipate employer exposure, and no proactive method of tracking claims submitted by contractors throughout the duration of projects. Step in the SCL protocol. I will apply its utility to a real-life war story, but first I want to place the view in front of you that the protocol potentially addresses the gaps in standard form contracts by setting a framework for claim preparation and review that can be applied across cultural contexts, across varying levels of skill available in the contract administration market. How? So let's start with an introduction to the 2017 SCL protocol. So, as it's been suggested, every practitioner in this market needs to have a copy to hand of the protocol. I keep mine in a booklet format, and it stays with me wherever I go. When you go to the intro, the object of the protocol is to provide a useful guidance on some of the common delay and disruption issues that arise on construction projects, where one party wishes to recover from the other an extension of time and/or compensation for the additional time spent and the resources used to complete the project. The purpose of the protocol is to provide a means by which the parties can resolve these matters and avoid unnecessary disputes. A focus of the protocol, therefore, is the provision of practical and principled guidance on proportionate measures for dealing with delay and disruption issues that can be applied in relation to all projects, regardless of complexity of scale or size. I've paraphrased. So the protocol sets standards on the methods of delay and disruption analysis that are acceptable to use on most projects, I'd say all of them. And critically, the protocol encourages auditability by providing detailed guidance on record keeping. So, addressing the gaps, setting the framework. We see this from the core principles, just to give a high-level review. I'm sorry, wrong way. And ultimately, these can address all of those common complaints. Sets a common language. When you read all the definitions, we can all speak across whatever jurisdiction we're operating in. What is an activity? What is float? What is an as-built program? Standard setting. Methods of delay analysis and how to apply them. And then, of course, auditability. Let's stick with auditability and the importance of record keeping. I shouldn't have to explain how important this is, but I've been asked by contractors around the world to come in and talk about record keeping. What do records do? They preserve the valuable evidence of witnesses for later use during disputes that can drag on for years and years. It's the records, the contemporaneous records that tell the true facts of the project. Well-maintained records can facilitate settlement, which is ultimately what I'd like for all cases to arrive at when they don't go to arbitration. And well-maintained records can, of course, reduce legal fees. And of course, pages 12 to 22 of the SCL protocol set out the importance of every kind of record that we might need. Now, getting to my story. A few years back, and over a period of about 4.5 years, I was engaged actually by the employer, but I'm going to give the contractor side, to work side by side with it, a claims consultant, and around 15 separate contractors to resolve legacy claims that had been pending on one of the mega projects in Saudi Arabia. The employer had been faced with claim submissions plagued with a number of the common complaints. I've set them out here. I won't read them all to you, but you'll see the headlines: poor qualities of contractor claim submissions, poor methodology, variations that could undo the competitive bidding process, and then leading to unsubstantiated awards that eventually couldn't get paid because they couldn't get past auditability. So, what did the employer ask me to do? They suggested that we come up with a document that could be offered to all contractors that would help them assess the claims and ultimately get those claims paid. And so how did we set out doing that? We created a bespoke claims resolution protocol, heavily following and tracking this wonderful guide. For delay claims, we set out the acceptable methods of delay analysis that the employer would consider and how those methods should be applied to retrospective claims. We set out the various heads of costs that we would be considering by looking at, in general, the cost submissions of the various claimants. And we set out the necessary evidence that each of the contractors would need to provide in order to have its claim considered. And of course, this raises lots of questions about, well, this wasn't in the contract. Well, we're in a dispute setting, trying to avoid disputes, and we're trying to get to payment. So all of the parties eventually said, this is a great idea. Let's apply this to our projects, and let's resolve these claims. So, after going through this process over, let's say, I'd say a year-long period, so not a short process, but certainly a detailed one, we were able to effectively resolve out of 15 contract packages, I'd say 10 to 11 outside of formal arbitration, and we were able to get extensions of time for the contractors, even if, not as long as they would have desired, but a fair assessment of those EOT claims. And for the contractor side, most importantly, we were able to resolve the heads of loss in a way that was auditable. And this is key because without auditability in most jurisdictions, a settlement can't be entered. So we were able to have the contractors come up using the framework of the protocol, all of the cost records that were necessary to arrive at settlement. And where those records couldn't be located, unfortunately, claims couldn't be paid. So that's a short story, I hope, on the effectiveness of the protocol when actually read, when actually used, and when actually applied to projects. When I have new associates join my team, this is one of the first exercises they must do, which is to actually sit with this short document, read it, so that we can speak the same language, which is resolution of contractor claims. Now, I was also asked to briefly comment on where the protocol might go a step further. I think it's a wonderful document, but there are areas, and maybe we'll get into discussion of where we can think in the future. Provisional sums. This is becoming more and more a topic of conversation in the jurisdiction where I practice. So I'd like to have some conversation on how the protocol might be extended to cover some guidance there. Progress reporting. While it sounds like a fairly mundane topic, I think any of us who have been in arbitration proceedings and we're looking at the progress reports, we'd like to see them be a little bit more helpful. So I think we could all contribute to some guidance there. And then guidance on taking over. All too often, we're in the project, in the life of the project, and we're living with it day to day. But we're not thinking of taking over. And so taking over issues only come up towards the end of the project, and that's where we see employers starting to get creative on what the requirements are for taking over. So it would be great to have some discussion and guidance over how parties can start thinking about the taking over process from day one. And I think I've concluded well within my 10 minutes. Thank you.
Thank you very much. Thank you very much, Rena. This protocol is not only helpful when disputes have arisen. It rather helps more to avoid disputes and how it happens. Protocol also talks about the industry best practices about record keeping. What kind of records industry generally keep and they should keep. And you all will agree, if records are kept, proper records are kept, and these are exchanged with the other side, disputes can be avoided. Most of the problems come when claims are raised without proper substantiation. Whenever one has to raise claim, what is that one is supposed to do? We call it CEES. Cause, effect, entitlement, and substantiation. Protocol helps us in all the four aspects. It tells us what kind of records are kept and should be kept. If it is about the causation on the liability side, which of the two sides has caused delay. If you have baseline program, if kept, if it is updated periodically as and when delay events occur, if it is exchanged with the project management consultant, engineer, or the other side, who checks it and decides the extension of time if needed contemporaneously, not like the way we generally do in India, where we say, generally employers, engineer will say, provisional EOT granted for X months. That's it. You are inviting problem, and protocol says never ever have this wait, watch, and see. No, do not wait and see. Do not have this approach at all. If there is delay, determine the delay contemporaneously, have proper delay analysis. This can be no region that employer's project management consultant of the project does not have scheduler or planner. You have external independent experts, take help of them. Do it, you avoid dispute. Else, you are inviting dispute. And I'm reminded of what Melod Justice Bindal said about why can't we have SOPs? In fact, Justice Malhotra also talked about this. SCL protocol existing today is undergoing a process in which recommendations are being invited for updation, because industry practices evolves, law evolves, technology evolves, therefore periodical updation is required. Today, I am making an announcement, that is, that SCL India is going to set up a working committee and going to prepare questionnaire for Indian construction industry, inviting recommendations and suggestions so that Indian peculiarities in the dispute in the industry can be taken care of. We are going to send that recommendation for this SCL delay disruption protocol updation for the new edition. And if need be, like Malaysia did, like Sundara did, we may also think of having SCL India delay and disruption protocol, which will take care of the peculiarities of Indian industry. All is about having some standards so that it helps the arbitrators, councils in bridging the gap. That is what I thought we will talk about. Now, I'll go to Mr. Sundara Raju, who will give tribunal's perspective. Mr. Sundara Raju.
I think it's good afternoon, colleagues and friends. It's an honor to be in SCL conference again. SCL is actually driven by individuals. I remember John Tuckerberry talking to me when he wanted, and Anthony Levers was actually the chair at the time. He talked to me about, why didn't you set up SCL Malaysia? And I still remember with Anthony Levers and John saying that, look, we can give you some seed money, but you have to organize it. There is no secretariat. That's the difference about SCL. SCL worldwide are groups of people with no secretariat. That means you actually support yourself. I think it stems from the fact that John had this problem as the chair of the Chartered Institute of Arbitrators. There was an incredible bureaucracy. I've been president of the Chartered Institute of Arbitrators. Again, I see the cost center of the entire process is the secretariat. So I think there was this attempt. So far, I think it has worked quite well because it is dependent on the choice. I'm going to talk about, going to talk about the overview of what the protocol is supposed to do. Again, this protocol was actually devised by volunteers and then using the auspices of SCL, particularly in Mother SCL in England, and then working it out. I think the real thing that comes out from all this is to provide some kind of guidance how to deal with common issues relating to delay and disruption. And how do you actually deal with extension of time, use of resources, and then basically bottom line is to avoid disputes, to resolve disputes in a logical way. I'm very fascinated by Mr. Ratan Singh saying that when a problem is given to arbitrators, they all seem to have come up with different answers. But I think it is maybe a bit exaggerated because I always believe that there's only one right answer. The right answer is what the arbitral tribunal decides. Just like the judges in the Supreme Court or wherever, there's only one right answer. For that moment, that is the right answer because looking at all the facts and the law, that answer will be devised. But I think the range really comes from perhaps within that, unless you get it completely wrong. Everybody will then say it's completely wrong. But when you get a range of answers, it is all right. So I think that is very important, and I believe that the protocol is aimed at that. It is a protocol that actually says one size fits all. It's a generic statement, and you say it can use for any type of project. I mean, this is my own reading of it. Perhaps I'm wrong. But I think the more important thing, it does not override the contract. I think that's what is in the contract is what is agreed by the parties, and that is not overridden. And I think the idea basically is to improve the management, the administration of the contract. And when there is a dispute, there is some common facts. Arbitration is very fact specific. If you actually do arbitration, you realize most of us hardly look at the law until we get caught in a situation where we have to explain competing needs. But normally the facts itself will resolve the dispute. So I think, and what will happen is that when things are moving into disputes, the real problem is how the decision-making process of the arbitral tribunal or the adjudicator is to be explained. So I think that's where we will need this kind of standards. So the protocol itself, there are 22 core principles, which basically it all relates to, in fact, there are 6 sections in the protocol, and one is the summary of the core principles, and the core principles talk about record, extension of time, delay, disruption, 22 of them. And then part A talks about the overview of the concepts of delay, disruption, and acceleration, sometimes to speed up to catch up with time. And then part B talks what is the guiding principles of each of the core principles. And then part C talks about financial heads of claim that often rise in the context of delay and disruption. And then Appendix A, Appendix B, definitions, glossary, and then types of records in Appendix B that should be for the 6 categories of records for delay. So I think going on to that, I won't go through the actual thing. Now the next thing is to, what are the key points to note? I think the 2017 protocol removed the model contract clause. There is a suggestion now, I mean, we will discuss this, whether to incorporate the protocol into the contract, whether it should be encouraged. In fact, I think by removing the model clause, they have actually suggested you shouldn't do that. That means you must look at it in a way that is relevancy, most important. And then I think you also have to see where you are. I mean, the protocol is actually an English-based product. I think generally it was, I mean, the brains behind it, I mean, the thought thinkers were from England when they thought of this. And then I think it has become developed as based on the UK construction industry. So I think there, the record keeping, although people complain about record, is much better. English write better, they keep more records. If you see a letter coming to you, it is written very elegantly, and it covers a lot of things. So I think one of the things that you realize after that, that it is actually not meant as a universal thing. And from me, from an arbitrator's perspective, is to actually look at what is the relevance of the protocol to the tribunal. And then what is the global recognition that is given in any situation and where you're sitting. And then what would be the limitations and criticism. And then looking from an Indian perspective, I'm doing more Indian work, and I'm fascinated by the way things are done in India. It reminds me of Malaysia. You know, there's what we say, a certain element of looseness, which is quite useful because things are done. You know, it can never be done. I think that a lot of criticism about the looseness, but that's the only way in a society that is moving very fast, changing, to build things. But I think if you look at the historical basis of India, India has built magnificent buildings that stand, and we look at awe, you know, what kind of contracts they used. I don't think so they had a delay protocol. You know, so I suspect that we will find the balance. because I think one of the important things that are coming in is, for me, the early days I used to look at the highway contracts in India. And the National Highway Authority, in fact, I think is a sort of a flag bearer for the introduction of feeding into India in a very, very big way. So it is interesting to see that. And I think the first thing that we should say, it actually gives you a standardized framework. And you will find they have identified 6 ways that you can actually analyze delay. So they talk about impacted as planned analysis, time impact analysis, time slice window analysis, as planned versus as built window analysis, and the longest path analysis. And if you are confused about it, join me. Because this is the terminology that is used by claim consultants when they come and present evidence before you. And actually the most important thing is to look at the method and see how it specifically fits into the project circumstance. And I think the real challenge to the tribunal is to see whether it is an appropriate method that has great explanatory powers. For us, when you sit in a tribunal, you want to understand the nature of the evidence. What does that effects mean? Does it say this? Where does it fall? You know, that is very important. So the process itself. And I think there is a recognition to that the most appropriate approach based on the specific circumstance of the project is actually the one that will help the dispute resolution process. And it is interesting, there is an early case where Mirant, Asia Pacific Construction Hong Kong versus Owe Arup Partners International, 2007, English decision, which basically said that we will actually reject this method of analysis because it is not in accordance to an established protocol like the SCL protocol. So it's quite interesting that there was some kind of benchmark kept. The fact that the English courts decided there's a benchmark is quite important. And then the emphasis next is that they would reject unrecognized or unconventional method of delay analysis. But I think really for the tribunal, as an arbitral tribunal, you will have to look, in fact, the first justification that the expert should give is why he is using this method. I think that is very important. Then moving on is the first core principle. The first core principle is parties must agree on the records. In fact, Arjit is going to talk about it, how to do it in a particular condition. If actually in a FIDIC contract you have general conditions and particular conditions, if you can actually put it in the particular conditions of the kind of common records that must be maintained, that will really help the dispute if it ever comes about, or maybe even resolve the dispute before it even reaches that point. So I think that is the first thing. And of course, it could include critical path, schedules, site diaries, meeting minutes, and then basically, again, it must be objective and it must be accurate. Different experts tend to sometimes come to an arbitral tribunal and present their own techniques, which is convenient to explain the way they think the issue has to be resolved. And it may vary. It may vary. So I think the important thing is that to use the protocol to see how relevant, how on point the method selected by the expert is. So I think the idea is that don't get confused by the experts. In fact, experts, I find that sometimes elucidating the issue sometimes confuse me, and I will try to figure out when I'm doing it, and then try to make it simple. Actually, a lot of things are simple. You must go back to first principles again. Always first principles, look at it, look what is the cause and effect. You see the relationship, see the mitigation, and I think you will get that. And I think the most important thing is that in construction arbitration, there is a lot of facts. And what is the relevant fact is the most important. And the relevant fact to that particular issue that has been talked about, it is a fact that the protocol is very, very popular. I mean, just looking at the downloads, it's one of the more successful products that have been produced by the SCL. And I think, and its impact, I think, mostly is in common law jurisdictions. Of course, in the Middle East, which is Dubai, where there's so much construction work going on, it is becoming more and more important. But I think it's due to the fact of the number of experts that have come in there, both lawyers and experts, engineers, and other people who are all basically common law trained in a civil law situation. And also, I think there's a superimposition of other kinds of better ways of doing things. Better ways of doing things, and that has been very important. So I think also the courts have started to, this is about 50%, UK is the most, UAE, Qatar is about, let's say, 15%, then Australia, Hong Kong, all common law, let's say. And if you go to China, you don't hear about the SCL delay protocol. I've never heard. I mean, I've done a couple of disputes in China, and it's not been actually presented in that way. Because the Chinese contracts are a bit different. You will find that, I think they don't read the contracts. They have a standard form contract, but they don't read the contracts. The SOEs actually come out with their contracts, which are quite interesting. And then they will actually look at the end product, and they will say they can produce it, and they will just go ahead, and their record keeping is terrible. Because I think everything is based on approvals up from head office, and it's quite interesting, it's done differently. So going back, I think it is also helped by the fact that the courts in these particular regions that we have been talking about, the common law regions in Australia, in Hong Kong, in the UK, have actually endorsed the protocol in one way or another. It could be explicitly or impliedly. So I think that has helped, and I suppose they look at a method and say this method is good, it is applicable in upholding the situation. I'm going to go faster a bit, but let me move on to limitations. The cases, I think they are there, the slides will be available, and I want to go to the limitations now. I think the most important thing, the protocol is not binding. Remember that. It is just a guidance. And once you remember that, you will not get obsessed that it must be the method that you are going to use. So I think, of course, one of the things when I first started arbitrating, until the 1990s late, there were no experts coming before the tribunal. The only experts that were the arbitral tribunal themselves. Normally, they will get an engineer or architect or a construction lawyer to actually sit. But nowadays, it is almost 100% sure that you will have a team of experts, ranging from delay, quantum, forensic, and it just goes on whatever areas where they need expertise. So I think that is one of the big change that's coming in. And, but I think once you accept that it is non-binding, then it is very important. Then you also have to look at the jurisdictional variation. And you will find, for example, in America, the SCL protocol is actually has its equivalent in the AACE International Recommended Practice. So in America, they won't use the SCL protocol. They would use their own methods. I'm not very familiar with China because I've not seen any kind of protocols that have been given. And then I think the real thing, the arbitral tribunal will always disregard the protocol if it conflicts with the contractual terms. I think, so check the contract, whether there is a congruence with the SCL practice procedures, and if it is not congruent, the arbitral tribunal will normally disregard it. Looking at the Indian perspective, I think Ratan and you have mentioned this, we are in, I think I put myself in the Indian perspective, we are in a different level of development. We are growing very, very fast, whereas England has actually stabilized. I think the construction industry is generally humming along as it does, and replacing buildings and maybe one or two big projects. Here we have projects that are massive. I mean, you're building steel plants, power plants, roads, highways, and all of this is a completely different perspective. Sometimes you have never done it before, using that particular contract form. And I think it's very, very important to understand. And except for the organizations like the National Highway, where they have their standard form contracts and all these things, many of the public undertakings, especially in India, do not have standard forms. They will have modified standard forms, but they themselves won't have a standard form they will use for everything. So I think and I also don't know whether there's a national standard form of building contract. Most countries have them. In the old days, JCT was in control in England, and then after JCT, then I think now is the NEC, and there's this natural tendency to use standard form contracts, particularly where there is actually negotiation on the terms with the contractor, the employer. I think the other thing is that everything is informal in India. There's a certain level of, like Malaysia, certain level of looseness. And then, okay, the client is a very important person. Because the client actually drives a lot of things. Variations will come from the client. The delays are sometimes caused by the client because they have different requirements. So a client-driven thing would actually suggest that the SCL protocol is, I don't want to use it because it will show and it will blame us. It will blame us that we did not do our work properly. In fact, I'm going to comment on something about taking out the arbitration clause. I got a strange feeling someone doesn't want to be accountable during the time when the arbitration is done. Because the arbitration normally nowadays 2 years. I think ICC arbitration will finish, Alexander, within 2 years easily in India. In India, I think maximum is 2 years. 1.5 years, we can even wrap it up. And I think when you get that decision, it is so detailed that somebody will actually be told that you didn't do this, you didn't do that. So if I were the guy, I said, no, better not do it in arbitration. Let me retire first. And then after that, it can be taken care of. I'm just suggesting, I'm just looking at the dynamics of it. But I think that is also the other thing is that there's a fragmented project culture. The expertise is concentrated in certain organizations, certain persons. And that is, for a country like India, is not enough people. So I think those people who are very, very good are world-class. But there's not enough of those kind of people. I mean, for example, I consider Arjit world-class because he's on the Presidential Palace of Adjudicators in FIDIC. Even in Malaysia, I don't think so we have anyone, but he did it, But I think it takes personal effort to do that, and there's also not, the skills have not developed. I think that's the other problem. So finally, let me conclude. Personally, I think that we should regard the protocol as a respected authoritative information tool, but it is not mandatory. I think that is the most important thing. And I'm quite sure that when you decide to use it, and I think Arjit is going to talk about how to try to use it, how it will help, and how I think it will improve the construction industry in our jurisdictions by actually instilling what we say a certain level of discipline, which may have a cost impact to it if you fail to actually adhere to it. Thank you so much.
Thank you, Sundara. Thank you very much. Sundara was talking about Indian peculiarities. Let me be very frank with the audience. In India, we have a culture where contractor says all delays, maybe of 3 years, are attributable to the employer, also referred to as client. Employer says all delays are attributable to the contractor. What they bring on the table of the arbitrator would be various emails and minutes of meeting. That's it. And then quantification of the claim would be again based on what they alleged. Now, challenge for tribunal. Tribunal looks at it as a challenge, how to decide which side delayed for how many days and so on and so forth. And I strongly believe whether employer is attributing delay to the other side or contractor is attributing delay to the employer, whoever is attributing delay to the other side owes the burden to prove with certainty that delays were critical in nature, delays were on critical path. That's it. How do they do that? Burden is on the contractor or the employer who is raising its delay claim. How they will do it? If contractor says that I was not given approval for a particular drawing for a particular period, first thing tribunal should ask that particular contractor or the employer is whether during that period absence of approval had the effect of adversely impacting any activity on the critical path or not. Once tribunal takes a firm decision, then it will become culture in India also. One who attributes delay on the other side owes this obligation and burden to discharge that delays were on the critical path. When we talk about, so delays, if are attributed to the employer solely, we call it excusable delay. If delay is on the side of the contractor, we call it non-excusable delay. If delays for a particular period are on the head of both sides, we call it concurrent delay. Based on this, we decide whether a delay is compensable in nature or not. Excusable delay, compensable in nature, contractor or employer gets that. Non-excusable, not compensable. Concurrent, you get extension of time, no compensation. This is broadly. So once you become firm, when it is on the liability side or quantification side, if contractor just brings on record some statements or tables saying that these are the losses caused to me on per day basis, where are those documents which protocol says you should maintain, cost statements, all those documents? Unless you place on record those documents, you had no discharging your burden, therefore you get nothing. There is a big debate going on based on A.T. Brijpal judgment, Dwarka Das judgment, and high courts are taking divergent view on loss of profit claim where there is premature termination of contract. And Supreme Court had gone to the extent of saying that contractors generally will earn profit. This is not how it should work. Contractor, yes, they work for profit, but they will have their records in place, tender allowance, tender documents, tender breakups. Or they should come and they should have the quantum analysis, how much they would have incurred if they would have worked for this project, and how much was the original cost. Difference between the two, minus the overhead, minus the money received, comes as a loss of profit. So the judiciary as well as the tribunals will have to be firm on these issues. Burden is on you to demonstrate delay was on the part of the other side. Place on record all relevant documents. If you do not place on record, you don't get anything. This is the culture we have to develop. This is what I was talking about. Now, I'll request Mr. Ajit Misra to give the perspective of employer stroke client stroke owner. Ajit, over to you.
Good afternoon, sir, and thank you very much for inviting me to this session. I've been tasked to speak about the employer's perspective on the protocol. I'm not here to discuss what protocol, what items of protocol favors employer or disfavors employer, or when contractor is drafting contract, how it should handle protocol to favor the contract from the employer's perspective. What I'll discuss today is, I'm an employer, I'm going to float a large infrastructure or construction project, and during so many similar seminars, I have learned about the goodness of this protocol. I wanted to utilize it in my contract. My worry is how to utilize it. When I read the very first page of the protocol, it says that it is non-binding. Professor Sundra also said, Rena already said. Then when I further deep down into the protocol, I further find that earlier the edition 1 was providing some model clauses how to use protocol in the contracts, but in the second edition, 2017, has removed those model clauses. That troubles me. Then how to use it? If I put a mere reference to 2017 protocol in my contract, is it going to help me? So this is my discussion today. Please bear with me. I'll not take more than 5 minutes because a lot has been already spoken by few speakers, earlier speakers. Can I have these slides? This was the original presentation scheme, but I'm skipping the few portions of this. This is the summary of what my previous speakers had said. What is the status of protocol? That once assuring thing I come to know is that it is applicable to all contracts, all projects, regardless of their complexity. Then I'm also told that it must be read in conjunction with project-specific terms. They are not overlapping. They are not in conflict with each other. I'm also being assured by the protocol that it is universally acceptable across all kind of contract forms, and it can be referenced in contract data or special conditions. As the general said, it said. The only thing is that it has removed the model clauses. A little bit troubling thing is protocol embodies the good practices, not the best practices. So my first worry is I should not strive for the best when I'm approaching this protocol. but I'll come to this in a little bit more detail. The protocol says that the application or of any method or any conclusion based on the protocol should match with the common sense approach, or you should, when you are dealing with different methods and all, or the first thing is you should try that your conclusion should match with the common sense application. Fair enough? Now I'm trying to do what the first edition removed through the model clauses, and I'm thinking of incorporating it my tender document. And I'm evaluating, can I just incorporate it through a reference, or in that case, will it be sufficient or not? First thing is that it is non-binding, or said so many times. And if I'm putting it as a mere reference and something props up during the dispute, I'll not be able to convince my arbitrator, the Sundara's role, or any judge that what should be the clear, decisive position. So all it says is that a mere reference will give a persuasive at best and may not be enforceable. It gives ambiguity without specificity. If you just refer the protocol like the parties shall follow the SCL protocol, it will be unclear that which principle apply on, say, concurrency or applicability of float ownership, whether it overrides the conflicting contract provisions or not. That will largely depend where you are actually referring the protocol, where you are referring in your technical specification, or you are referring it in a particular condition, then the priority of the documents of the contract will come. But still, since within the protocol itself, it's only recommendatory, so the issue of conflict will come. This may lead to interpretive disputes, and you may know the both side lawyers can take so many interpretations and trouble you during your dispute resolution process. Another thing is that sometimes it may conflict with your governing law, this is largely based on English law, and us being the common law, we can say that we are generally aligned with the English law, but on so many other, principles, legal principles, Indian law is at difference with the English law. So that part you have to look into, otherwise you will be problems will be there while interpreting the contract clauses. Then the operational framework, it asks about the contemporaneous record, defined risk events, involvement of delay experts and all, prescribed claim procedure. But if I talk about the big infra projects, yes, these things are there in place, but most of the general government contracts are missing these aspects. So on those kind of contract, probably the utility of the SCL protocol will be very, very limited. So my conclusion is that mere reference is not sufficient. You have to some kind of, what SCL protocol stands as of now is a soft law. From that soft law position, you have to incorporate it into the contract to have its effectiveness and to give its teeth to its provisions. But if you are giving it, incorporating in the contract, you cannot do it, simply. You have to customize it, because protocol is the directory. It suggests so many places. It's only suggests. It doesn't give you a clear guidelines. It just give you some kind of food for thought. So you have to specify all those places where there is a flexibility or there is a choice. You have to clarify specific to your project how to use it. This is one sample clause. Again, I'm coming back to the model 1, edition 1. If you are going to use it and forget about what the protocol generally says. You bring out the core principles, their concepts into your contract specifically. And my idea is the way we have our standard conditions, like standard contracts like FIDIC, NEC, and JCT, so many other things. We customize these standard contracts through contract data and particular conditions. Similar kind of concept has to be brought in to incorporate SCL protocols into infra contracts. And that's how I have tried to bring the idea, is that how you are incorporating the SCL protocol, you are incorporating it, and then on the third paragraph, you are suggesting the modification along with the clear precedence where it will fit into the priority of documents. Some of the, I pick up one or two just to incite your thoughts, how it can be done. If you see the principle 1, which talks about the program and records, and I'm comparing it with the FIDIC contract form, which is the standard contract form for my contract. That FIDIC contract also legislates how to maintain the records, but when I compare the document keeping in the standard FIDIC contract, and when I see the document keeping in the SCL protocol, I find that SCL protocol document keeping is more rigorous and more voluminous. It talks about the 6 different sets and over 50 number of documents, records, etc. So my suggestion here would be that we should adopt what SCL had suggested in their Annexure B, I suppose. Annexure B, put it in our particular condition of FIDIC, and then we say that we are referring now SCL protocol to as reference to the particular condition. Same thing can be done with the program. FIDIC contracts also deals in detail about the program. We can incorporate like that. So my concept here would be that, like the way we have our particular conditions, we should have the particular principles to SCL protocol to be incorporated in the contracts. Same, all these are things to be discussed, but I'm skipping it. But what is the flip side of it? But if we are doing it, or rather overdoing it, it could lead to the administrative burden. A lot of task has to be done. And if you are not mature enough, you don't understand the principle well, probably it will lead to a lot of confusions and more disputes. Rather than killing the disputes, it may lead to new this one. Superficial adoptions, obviously it will be troublesome. The procedural rigidity, probably one of the core principles, one of the good part of the principles is the flexibility. And if you are putting it too many particular principles, probably you are killing that flexibility part, and over legalizing the protocol can undermine the core value of the flexibility, industry acceptability, and proportionality of the dispute sharing, risk sharings. So, but anyway, to take it forward, something has to be done, and something has to be done in a concrete, clear manner. Then only this protocol can gain teeth, and we could be able to harness it's the good and beauty part of the protocol. Thank you very much.
Thank you, Ajit. Now, Hamish has heard all the panelists. So he'll be in the best position to give his concluding remarks with his experience. Thank you.
Indeed. I think Lady Justice Malhotra made a number of fundamental observations. Two in particular really stood out. Arbitration is culture sensitive, and arbitration is law sensitive. Most international arbitration tribunals are not binary. They tend to be a blend of common law and civil lawyers. And there is always, in my view, a preference towards looking at as-built information, gleaned from data, from witness evidence, and gleaned from how the contract or law works. Thank you. So how does the protocol travel, and how does it work when we are in the context of a dispute? I've never seen the SCL protocol codified into any contract, whether that's a standard form variation or a bespoke, and I think Ajit's ambitious task will be very novel. But it's essentially a document for experts, I think. So at present, any expert who wants to use the protocol only needs to download it from the SCL website. But beyond this, experts are left to their own devices to navigate through its content, select what they believe is the right methodology, and then perform some sort of analysis based upon their subjective understanding. If we put this into context, that there is a risk through misinterpretation of the guidance, a risk of disregarding or missing entirely some of the key recommendations, and then performing analysis which may not be consistent. Here we had one expert that used the impacted as planned in Windows, and the other expert used a collapsed as built. But the court struck out both. And this is an important case because what the judge said was that the fact that the method, the label, appears in the protocol does not give it any standing. And the fact that a method which is otherwise logical, rational, but does not appear in the protocol does not deny it standing. So the ramifications of this case internationally were significant. It marked a shift away from experts saying my methodology sits perfectly with the protocol and so on. But when one looks closer at this case, the analysis performed by both experts was flawed. It wasn't the protocol that was necessarily flawed, it was their interpretation of it. The advice in the protocol had not been followed. There are other cases, and I've just put a couple on there, just to give you an idea. And there's an English case. The protocol landed in around about 2002. As soon as it came out, there was considerable unhappiness with it. And I remember in 2006, October 2006, there was something modestly called the Great Delay Analysis Debate. And this debate involved 4 self-appointed leading experts explaining what they thought were the competing methodologies. The main proposition at that debate was whether time impact analysis, which the first protocol strongly advocated, should be the best or the model or the most acceptable process. That motion was defeated twice. It went to a vote just like this conference, and it was not agreed. In fact, none of the 4 processes that were being advocated or methodologies were supported. There was not a majority for any particular one. So, as early as 2006, there started to be a switch towards common sense. And the common sense narrative came from some of the case law, that some of these methodologies can give very artificial outcomes, very distant to what the tribunal and judges intuitively believe must have caused actual delay to an actual critical path. So the common sense narrative took hold, and then in 2017, it became a fundamental aspect of the protocol, especially when it comes to methodologies. And you'll see that the get out of jail card of common sense is mentioned something like 9 or 10 times. I won't dissect all the problems or with some of the recommendations, but this one does irritate me a lot. Float. The protocol first edition and the second edition came up with this concept of what float is. It doesn't distinguish between inherent float or end float. And then it makes the observation that the float should belong to the project. But I think this is total nonsense, because there's nothing about public policy or the construction industry or an as-planned program that says float belongs to the project. Perhaps it belongs to the contractor who's taken the lump sum risk of constructing a project to a sectional or end completion date. But fundamentally, it conflicts with either what the contract suggests or different laws. Singapore, for example, takes a view that the float belongs to the contractor. So there are some inconsistencies in the protocol that do need to be reflected upon if one wants to incorporate it. Concurrent delay is another topic. I think the SCL protocol was very good at socializing the concept of concurrent delay. But Keating, the textbook on construction law, had covered concurrent delay for decades. Did it really need codification in the way that the protocol tried to do it? What the protocol has really done is create confusion. Different experts have different views as to what is critical concurrent delay. And arbitral tribunals are often presented with graphs like this to say, well, this is contractor responsible, this is employer responsible, it was concurrent. I've never seen concurrent delay. I don't think it really exists. I think it's something that can be constructed based upon different methodologies that different experts might try to use. It doesn't exist. And there's so much law that comes out of concurrency, and I know there's a session that my colleagues are doing later on, but this is an area that the protocol does need to look at. Well, what are the alternatives? If we look at international arbitration, it isn't just made up of experts that follow the UK or common law approach. A lot of petrochemical disputes, oil and gas disputes, will have experts that live somewhere other than London, the US. And here, this forensic delay analysis, the recommendations, the best practice guideline, comes in very important. Fundamental difference, the recommended practice is only designed for when one evaluates delay in a dispute setting. It's not about the normative proposition as to what somebody should do. It is undergoing review, and I think the new one is coming out soon, but it's much more serious. If you look at it, it's 135 pages just about methods. It's taking experts through what the methods are, rather than how contracts should be constructed, how float should be allocated, and so on. It defers entirely to the contract, and it defers entirely to applicable laws. What's next? I think the difficulty with the protocol is, who is the expert? Is it the protocol, or is it the person? There's so many people eat the protocol and say, I'm doing something that the protocol wants me to do, therefore I am an expert. And that doesn't work. Is it a drafting tool? My colleagues, Rena and Ajit, are looking at how it can be used in practice. But is it a drafting tool? What does it really give us that the plethora of standard forms doesn't? And why, if it's so good, has it never been incorporated? Why do I never see it in any contract? And who is it for? It's clear that the recommended practice is guidance for experts, but the protocol seems to be telling everybody something, and that may be where we went wrong. What's next? I think Ratan touched upon the questionnaire that will be coming out in this jurisdiction, but there's other work streams that other people are looking at based upon the protocol and recommended practice. The main difficulty is bridging the different methodologies, not necessarily harmonizing them, but just bridging what they mean. So there is a couple of things that perhaps people should be aware of. One is the SCL in the UK is looking at getting people's views. I'm pretty sure, consistent with what happened in 2006, this next questionnaire will not reach any consensus. But there are a number of arbitrators, leading experts, Mr. Singhal is one of those, looking at a peer review of the protocol relative to other international standards. Why are we doing that? To make it not a protocol, but just a peer review, so that arbitrators who want to use it can at least understand how it correlates internationally. So how does it travel? I don't think it travels very well internationally. It's got a lot to do, and I think the American and this bridging document may well be a way to keep it active. That is not to say that it shouldn't be used to manage claims or to be codified in contracts, but as a dispute resolution tool, it has failed.
Thank you, Hamish. So, what we have summarized in this panel is SCL tells us what all records should be maintained, how you should raise your delay claims, disruption claims, how delay analysis for delay and for disruption or disruption analysis are to be carried out, and so on and so forth. One announcement. I can see sitting from here that lots of people are not able to get seats even. Some are standing outside. So one announcement that next year onwards we will have 2 days event in Mumbai. One, we will have bigger hall than this one. But ladies and gentlemen, for today, be ready for longer day. Thank you very much.
Thank you, panelists, for what was a very, very interesting panel. I would now request Mr. Mark Rollins, King's Counsel, to kindly felicitate the panelists on the dais.